So
Yes.
this concept of settlement and commitments have been again inserted on the recommendation of the industry, and it is in sync with the similar provision in the EU and USA and other advanced jurisdiction. It has been introduced after prolonged deliberation, on the demands of the industry to reduce unnecessary litigation in appellate tribunal in the Supreme Court, and an important steps toward ease of doing business. This is actually a step toward ease of doing business. There's no doubt about it. What it means is that when there is a case where the CCI, after the DG report has come, investigation has taken place, there is ample evidence of the company having actually committed the violation, right? Why should it go through the inquiry? Why should it hire? I should put to the lawyers and continue facing the court of inquiry before the CCI and then get penalized when it knows in the heart of its heart that it is an indefensible case. Suppose there's a case of a cartel which is absolutely clear. There are email exchange between the parties. There are tables given that what rate you should quote, what rate this company will quote, and they're absolutely clear evidence, direct evidence are there. Why should it can go through it? But what the CCI has understood is, except for the case of cartels, so cartels are most pernicious. So cartels are excluded from this. So cartels cannot take the benefit of settlement. For them, the leniency is there. For them, the provision is to go to leniency. You have to go at the right time to the DG and to the CCI and say, yes, we are in a cartel. Please give us a penalty waiver. So then the penalty waiver is given up to 100%. That is a separate thing. But for non-cartel violations, that is section 3, 4, vertical agreements or abuse of dominance, there is this window given now, and it is only after the receipt of the DG report, prior to the final order being passed under section 27 or 28. So CCI provides an opportunity to the party. Anyway, the DG can be summoned. DG can also will be also listened what they have to say, whether they object to settlements or not, and then they reject the settlement. They accept the settlement. They'll propose certain monitoring mechanism for that. How it will be settlement will be monitored. How will they do the? How will they cure the market from the anti-competitive conduct which they have done? Right? They will restore the competition into the market, and they will be monitored for some period of time. They'll give us terms and conditions of monitoring also, and monitors may be appointed also, and then they have to pay some sum. So it's like a penalty, which the penalty will have to be paid in advance to the commission. And the good part is that it's not appealable. So the other side cannot go and appeal. That, well, why have you settled? The settlement is non appealable. But the grace here is compensation can be still claimed. This was an issue of debate. In fact, I had also given this comment to the PSC that you should not let them go without compensation right. So suppose I have committed a gross violation. I've abused my dominant position. I'm a monopoly, and I've finished the downstream market. I need no case, but I'll not take name. Grasim is the worst case when I'm on the side of the other side. So I'm saying so. Sorry for saying that, but the point is they have finished the downstream market spinners in the viscous triple fiber product. So they are the monopoly. They are the only company in India which produce this product. So that being the case, why should they go scot free? Suppose the CCI, whatever reasons, enters into a settlement and a pitiable sum is being asked to be given, where the damage to the market is too much. What will happen? So those who are actually victims of that conduct must be given a right to claim compensation. Luckily, the parliament has seen that, and this has been retained. This has been introduced. Now the commitment. In the commitment, what happens is that is a stage where before the DG report, where the CCI has taken only a prima facie view, but the companies feel that yes, we are wrong. So they want to sort of give a commitment that we will not continue with this anti-competitive conduct further. But the DG report has not, the investigation has not started. Or even if the investigation has started, the report has not come. So at that stage, you can go and give commitments to the CCI. Let me tell you, all the cases in the world, whether it is against Apple, against Amazon, or against Google, they've all offered settlement and commitments in US. They never go through the entire process. They settle the case. They pay billions of dollars to the other side, and they settle the cases. That's how it happens in US and America. All cases of big cases are settled. Whether it's the Google publisher case, e-publisher, e-book case, all those cases. So this thing saying now has come to India also, and it's a good development, I would say. But here there is here again it is not appealable, but there's no provision for a compensation here. But monitoring mechanism will be there. I think the slide is self-explanatory. I need not explain further. There's another section which says that the terms of settlement and commitment, if are not they are not honored, then the CCI may even revoke the or withdraw the pass the order and continue with the inquiry if they fail to comply with the order pass and or they have not come out with true disclosure. They may have hidden something. Material, there is also a change of material facts. Then the CCI, apart from the penalty which will impose under an inquiry, after an inquiry, may impose a penalty up to legal cost of 1 crore also.
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000 plus laws and 24,000 plus compliances. All in an integrated platform that is easy to use with automated alerts and risk management capabilities. Is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management, request a demo at complinity.com.